Can I just, one bit of housekeeping. The chapter that your Lordship wanted is chapter 10 of the NICE report, and copies are being made available, and it's a bit more of a photocopying job than can be done over the short adjournment, but we hopefully will have them by 10:30 tomorrow morning.
Right, well I'm now committed to having to read it, having put you to all that trouble, but thank you. It's of marginal importance, I may fear, but you'd see why I want to see it. Thank you.
But there's another small bit of forest which is cut down to assist in this case. Ready. Would your Lordship Ladyship be kind enough to pick up Authorities Bundle A, tab 3, page 60. And in the structure of my submissions, I'm still in ground 1. I'm attempting to explain how we invite the court to interpret the interrelationship between marketing authorisations, manufacturing authorisations, Article 40, the compounding process. So that's where we are. Article 41 provides that member states are required to ensure that anyone who manufactures a medicinal product has an authorisation known as a manufacturing authorisation. And so the activity of manufacturing a drug usually requires a manufacturing authorisation. However, there is an exemption in Article 42. The authorisation referred to in paragraph 1 shall be required for both total and partial manufacture and for the various processes of dividing up, packaging or presenting. And of course, we say this is dividing up. However, such authorisation, what authorisation? The authorisation referred to in this article, shall not be required for the preparation, dividing up, changes in packaging or presentation, where those processes are two conditions. Firstly, solely for retail supply by pharmacists, dispensing pharmacies, or by persons legally authorised in the member state to carry out such processes. So, solely for retail supply is the first condition, and the pharmacy condition is the second condition, or other authorisation. The problem, of course, in Apposite was that Apposite was not a pharmacy, and therefore couldn't satisfy the first criteria of Article 40.2 bis, but both here in Mode 3 and in the IFA case, the situation is different because the proposal is that a pharmacy does the compounding and then supplies the product to the hospital which uses the product. And that's precisely the scheme that was in the facts for the IFA case. So in Mode 3, potentially, compounding can occur in pharmacies, and therefore the first condition, it occurs in a pharmacy, is capable of being satisfied. We then come to the second condition, which I think is where the challenge comes, which is where it said, but this is not for the purpose of solely for retail sale. And in order to answer that...
Retail supply.
Sorry, retail supply. My lady is right. Retail supply. In order to deal with that issue, would you be kind enough to look at Authorities Bundle 3, or C, at tab 28, the opinion of the Advocate General in the IFA case, and turn to paragraph 81, which in the original version was at page 693, but if you now have the effective version, I don't have the page number.
It's still 693.
And can I invite you, it'll be much quicker, to read for yourself 81 to 84.
the Novartis Pharma decision referred to in 83 is apposite.
Is opposite, my lord, yes. And we see that from 44, it's C535/11, that's at page 704, and that refers back to the number for apposite.
Yeah.
So the submission is that the interpretation of the meaning of the term retail supply includes a supply where hospital A is supplying hospital B, where hospital B is treating patients. And that's specifically adopted in the judgment at paragraph 77.
Provided there's a prior prescription.
Can I come on to the prior prescription point, my lady? Yes. I'm afraid I'm trying to sort of slightly separate out the grounds. I will deal with the prior
So
prescription.
say what you just said again then.
You
said the court approved this at para 77.
Yes, the notion of retail supply, my lady, the submission was the notion of retail supply for the purpose of Article 42 bis includes the factual scenario where Hospital A, pharmacy, compounds Avastin into separate aliquot, separate vials, and supplies them to Hospital B, where Hospital B is the treating hospital where the patients are treated.
Yes, you say separate vials, and I'm sure that's technically correct, but in practice we mean syringes.
Syringes, yes. The vial is attached to the.
I understand, that's why it's technically correct, but I mean, for our envisaging.
Yes. Very little files coming out of a big vial. But Lord, page 719, that approach is specifically adopted by reference back to that series of paragraphs in the decision of the Advocate General.
Is that correct? Immediately, I can only see the reference back is to para 79.
Well, my lord.
Oh, I see. No, all right. The reasoning is clearly that in the paras following 79.
It is, my lord. Yes. Yes.
Thank you.
Yes. And therefore, if it's good enough for Italy, it's good enough for the UK. And a hospital in the UK, which did that process, does not need a marketing authorisation. And the point about Article 42 bis...
Did you mean marketing authorisation?
I meant manufacturing authorisation. You're perfectly right. I'm sorry. I'll get back in the groove. Doesn't need a manufacturing authorisation. And the point about Article 42 bis, my lord, is that there are no size limits. So you are within that exemption if you are undertaking that function. And whether you're doing it for one vial, 100 vials, or 1,000 vials, makes no difference to the scope of the exemption, because what it does is it exempts the function from the need to have a marketing authorisation. Manufacturing authorisation. My brain has now got rooted on that. I'm now going to move on to marketing authorisations, and I hope not to refer to them as manufacturing authorisations. Right. So having made that submission, the next question is whether the compounding pharmacy requires a marketing authorisation to carry out the process of retail supply. an understanding of this, we say, starts with an understanding as to why the court differed from the Advocate General in apposite. So if we could turn to apposite, which is bundle B, at tab 23, and first look at the Advocate General. And the what happened in this case is that between the scheme and the history of medicines medicines directive is set out, as Malone de la Mare said, by the Advocate General at 550, paragraphs 4 through to 11. Noting, and I invite Lord the Court to note this, at paragraph 11, that the bolting on of successive features to a single regime was observed by the Advocate General to produce a result that was not always entirely coherent. And we are struggling with the consequences of that lack of entire coherence. Paragraph 34 of the judgment, of the opinion, at 553, the provisions of the German law are required, and that's where the requirement for a prescription arises under German law. Because German law says, in summary, you must have a marketing authorization unless you satisfy paragraph 21.2, which exempts products intended for delivery to a pharmacy in possession of a prescription for a patient and products which are put into a container without being modified. So it is the pharmacy that has to have the prescription, not the compounder, under German law. The German court asked for an interpretation of the meaning of the 2004 regulation, but the Advocate General at paragraph 47 agreed with the Commission that the question was really what the directive meant. And at 47, my lord. Yes. And at 54, the Advocate General asks the pertinent question, which is this. Second sentence. At what point, though, do the obligations concerning the authorisation cease to apply? Can it, for example, be said that since the first subparagraph, Article 6 of the Directive 2001/83 refers to a medicinal product being placed on the market, a third party may then modify the product without requiring any form of authorisation? That the legislation is, in other words, spent once the product has reached the marketplace? I do not believe it can. And then she looks at 56, at the use of the expression put on the market in other contexts, and then says at the beginning of 58, exhibiting her training as an English lawyer, that context is everything, with echoes of Lord Steyne in the Daly case. And she relies on recital 35 to say that it's the entire chain of distribution, and says, a sentence about 6 lines down, it is only spent when the marketing process can be said to have terminated. that's the key phrase we say. And she then says an authorisation must therefore be in place on every occasion on which the product concerned is made available to the market until the point at which the product has in fact been disposed of by being supplied to the public. Any other interpretation would fail to satisfy the requirement. Control be exercised over the entire chain. And so that's the Attorney General's, the Advocate General's position. But even given that position, can I draw the Court's attention to paragraph 76?
Hang on one sec. So sorry. Yep.
And I invite the Court, if you'd be kind enough, I know you were taken to this yesterday, and indeed Lord Justice Underhill raised this, but if you would just reacquaint yourselves quickly with the contents of that paragraph. And so that's mode 2, hospital's own pharmacy. So even even in the approach taken by the Advocate General in Apposite, mode 2 is not a placing on the market. And we respectfully agree with the Secretary of State.
She says it's a retail supply. She doesn't say it's not a placing on the market.
It's a completely different mechanism. It's taking it out of the scope of the directive altogether.
Yes.
Because of Article 3. So Article 6 never comes into play in the first place.
My Lord, I think that must be right. I think that must be right, and that doesn't survive the judgment of the court in IFA, which says Article 3 is not engaged.
So what do you say that we get from paragraph 76?
What she says, having pointed that out to me, I'm not sure I can press this very hard. She says, whilst I can't express a concluded view, since the precise nature of the disease concerned will not discuss in detail the court, it seems to me the exemptions I've described will, in the normal course, allow healthcare services to provide medicine on behalf of patients, even if those activities would otherwise require a marketing authorisation to be in place. So she seems to be saying, admittedly possibly through Article 3, which then can't be sustained, that mode 2, where you do it yourself, with prior prescription, I'll come to prior prescription, my lord, doesn't constitute a need for a marketing authorisation. And of course, marketing authorisation is needed if you place it on the market. But as I say, we have to treat the Advocate General's opinion with some caution because she was departed from by the court.
She got to the right place from your point of view about as regards mode 2,
By the wrong route.
but by the wrong route.
Yes. And we say the right route is to say there's simply no placing on the market because you're not marketing it. There's no market, there's no sale, there's no purchaser. You're simply using the drug internally in a hospital.
Right, but here what she seems to be saying is that mode 2 would be retail supply, so it doesn't need a manufacturing licence, and it will also not need a marketing authorisation if it can fall within Article 3.1.
Yes.
If it helps our position, can it be that retail supply here means something different, so that it's both, it is a retail supply for the purposes of manufacturing authorisation, Article 14 to this, because that's what Avastin says it is, but it's not.
And I'm afraid Mr. Perrett will be dealing with this point. and I'm not going to try and explain what his submission is, because I'm sure I won't do justice to it. Can I park that point? Moving on, though, the bigger point is how did the court reach the opposite conclusion? And the fact that the individual prescriptions were held by the pharmacy is noted at paragraph 17. Apposite submission is recorded at 26. In other words, the process of producing it has really been completed at the time it repackages it. But the view of the Commission, which is where in our submission the substance of the matter arises, starts at 36. And can I invite you just to reread quickly 36 to yourself, and then I'll try and explain what I think it means, that the language is not entirely straightforward.
They seem to have got us mixed up with marketing and manufacturing
Yes.
authorisations.
Yes, they do.
Didn't
It's even worse than I was about 10 minutes ago. But I think what the substance of this is as follows. The Commission's position appears to be, and if it's this, it's entirely logical, that no manufacturing authorisation was required by a pharmacy that was dividing up medicines for retail sale.
Retail supply.
No manufacturing authorisation for retail supply, and therefore a marketing authorisation shouldn't be required to complete the same sale. The position appears to be, and it would be entirely sensible, that the scheme of the directive allows a pharmacy to take a product with a marketing authorisation, divide it up for retail sale into smaller units, which therefore by definition won't comply with the SMPC. And if you're allowed to do that as a pharmacy for the purpose of retail supply, it would be illogical to also require you to get a marketing authorisation to complete what you are authorised to do in the first place.
Not just illogical, but wholly, it would make the manufacturing authorisation for practical purposes worthless, or rather the dispensation for a
The
manufacturer.
dispensation would then become worthless, exactly. And that is in essence what we say is going on in this process. Because at 39, the court, having gone through Article 3 of the regulation, then says that what is essentially a marketing authorisation needed for, it's needed according to adopting Article 3 of the regulation, the European legislature established a test for determining whether a given medicinal product must, in order to be placed on the market of the European Union, be authorised under the central authorisation procedure established by that regulation or under the national procedures implementing the directive. In the main proceedings, it's established that the medicinal product...
Where are you reading?
I'm sorry, paragraph 40, page 571.
You were reading 39.
I was reading 39, I'm sorry, I went straight on to 40 without warning. In the main proceedings, it has been established that the medicinal product Lucentis and Avastin have been placed on the market in the European Union and have in that regard a marketing authorisation granted by the process. And we then that then, we say, sets the scene for paragraph 42, which is, in such circumstances, providing the court does not in fact find the processes in question do not result in any modification of the medicinal product, pausing there, they are genuinely dividing up. So you're not adding something else to the product. You're not otherwise manufacturing it. You're doing nothing other than dividing up. I fully accept individual prescriptions, my lord, my lady. There is no ground for considering the activity thus carried out can be equated to a new placing on the market of a medicinal product included in point 1 of the annex of the regulation. And so, as long as you are dividing up, it's either a pharmacy or somebody authorised, and you're dividing up for the purpose of Article 42 bis and doing no more, then you don't need a marketing authorisation because you're exercising a freedom for retail supply which the directive expressly gives to either a pharmacist or somebody who's authorised.
But it's not the directive that gives it, it's a derogation that the member state can give.
My lady, the directive provides that, it comes back to the, can I slightly take issue with your ladyship?
Yes.
Or invite your ladyship to see it in a slightly different way. It's not the case that it's the requirement to have a manufacturing authorisation in order to be able to lawfully carry out the function is removed in the circumstances where the conditions are satisfied.
Yeah. So it's not a derogation
Right,
in the sense that member states may do something.
Exactly.
It's built into the directive itself and applies automatically.
Yes, in the case of a pharmacist. But your
Right.
ladyship is entirely right that in respect of somebody who's not a pharmacist, it's for the member state to create the derogation by authorising a defined group of other people than pharmacists to carry out the same function. But that's not relevant for our purposes, I don't think, because in the UK we are now told that that power has not been exercised, and therefore there are no bodies which have UK domestic authorisation under Article 42 bis to put them in the same position as the pharmacist.
Under relevant, yeah.
So, my lord, that's how we say that the, and then one looks at 44, because at 43 the there's reference to the Aventis case, the packaging case, and then 43, top of the page, the circumstances in the present case can be distinguished.
Sorry,
from
I was
those-
just.
I'm at
Something, let me catch up. Yes.
572.
Yeah, I'm there.
Top of the page. In the present case, can be distinguished from those in the issue in the Aventis, which concern repackaging for the purpose of parallel trading. The court observes, in particular, concurring with the Portuguese government, the activity carried on by the company such as Avastin occurs after the medical products at issue in the main proceedings have been placed on the market. And then at 44, second line, does not in itself amount to a placing on the market. So, this case, of course, does not answer the question as to whether a pharmacy, which is carrying on a manufacturing process which does not require then either a manufacturing authorisation or a marketing authorisation, is in breach of the directive, because of course this case was not about a pharmacy. But we then go on, in this case, rightly to say that the remaining paragraphs rightly say, well, that's all very well, but unless you bring yourself within 42 bis by being authorised, you can't go down this route at all. And Well, that's why the reference back to paragraph 36 and the position of the Commission we submit is the key to unlocking this case. Because if the Commission was saying, as we submit, they must have been, despite the garbled language, well, if you're within 42 bis, because you're doing something that's authorised, you've got to be able to complete the retail supply. Then the question for Apposite is whether or not they are indeed within 42 bis. And that was a question that was then referred back off to the National Court. And that's how we invite your Lordships and your Ladyship to read this case. Next.
I'm sure if there were something you would have showed us, but that rather clotted summary of the Commission's position, is that clearer if one looks at how the Advocate General expressed the Commission's position?
Not terribly, my Lord. I have looked at it and it's consistent. We think that's what it comes out of, but it's not entirely clear. It's consistent with, but not proved by. Can we next go to the next bundle of authorities, tab C, the next case, which is the AGCM case. The facts of this case.
So sorry, which case are we on?
Tab 27.
Tab 27.
Bundle C.
Yep.
For the authorities.
Yeah, no, I've got it.
And I don't know whether your Lordship has had either knows or has a chance to read this case, but essentially the factual background is perhaps summarised at 625 at paragraph 4 of the Advocate General. And that proven misrepresentation of the risks of using the product off-label led to fines imposed by the Italian competition authorities of 90 million euros against both Novartis and Roche. And we see that at page 664. For present purposes, the scope of EU law in this area was helpfully explained by the Advocate General at 48, at page 632. Can I invite the court, if you'd be kind enough, to read 47 and 48?
You've already taken us to 48.
I've already taken 48. I've already. So that's the summary, and the last the footnote in 48 is important because that's a reference to Article 1687. We'll see in the footnote at the bottom of the page.
It's footnote 13. Footnote
13, my lord, yes. And, my lord, I just need to take your lordships to the judgment at 52, for present purposes. In fact, I don't need 52, 58 and 59, which I think, I took you to this morning, which again sets out the wide freedom that is available interpreting the decision we say in apposite in accordance with the way in which I've invited the court to read that decision in a wide way. And then, my lord, if we can go to IFA, just to complete...
So wait a minute, do you say that in 58 and 59, the court in AGCM is agreeing with what you say is the interpretation of the judgment in apposite, which is that if you fall within the exemption for a manufacturing authorisation, what you do is not then a placing on the market for the purpose of needing a marketing authorisation?
Well, my lady, I do. I say that's the logic which links in the reference to Article 40 in the third line of 58 with the conclusion down on 50, later in that paragraph and in 59. Because the reference to Article 40 is a reference to a manufacturing authorisation. So you're allowed to do retail supply, and as my Lord Underhill, or just Underhill said, clearly that would be nonsense if then you couldn't actually do retail supply because you need a separate marketing authorisation in order to complete the retail supply.
Well, except that usually the drug will have a marketing authorisation.
Not if it's been divided, my lady. Yes. Because the dividing will produce a drug which is then supplied not in accordance with the marketing authorisation. That's the whole point in this case, is that the drug which is being transported from one pharmacy to another is not, having been divided, in accordance with the marketing authorisation pre-division.
Yes, thank you.
My Lord, I was then going to take the court to IEFA, but I think in substance, I've already explained the point, which is, and it's paragraph 73 of the judgment in IEFA at page 719. Subject to the issue of individual prescription, which will come back to haunt me forever, and I can deal with very briefly, and accepting, and I'm no linguistic scholar, but I respectfully agree with my learned friend Mr. Delamere, that there's an error in paragraph 73 in the third line which refers to prior. It means after. So the process happens after the product has been placed on the market. And then we see at 73, 77, towards the bottom of the page, again the linking together of Article 42 and the need for a marketing authorisation. Because 42 does not refer to marketing authorisation, it refers to a manufacturing authorisation. So that's a long explanation as to why a pharmacy that compounds Avastin does not need a manufacturing or marketing authorisation to supply the hospital with CB. Now, dealing with the individual prescription issue,
That's mode 2.
that's mode 3, my lady. Mode 3 is where hospital pharmacy A,
Oh, because
provides...
you add this point to your earlier point about all NHS hospitals are actually the same.
My lady, no, because this is all about the question as to whether a pharmacy, mode 3 involves a pharmacy which divides the product for retail supply and then makes the retail supply. to somebody else, not to your own patients, to somebody else, to another hospital. And that's the part of the Advocate General's opinion that I took you to the court to, that retail supply includes hospital A supplying hospital B. And so mode 3 is hospital A does the compounding, hospital B treats the patient, and the compounded product moves from hospital A to hospital B. That is the
The
ICE
same
scheme.
arguments will be deployable in relation to mode 2 if necessary, but they would be a fortiori because there would be one step in the supply would be absent.
Yes, exactly.
The only quote supply would be pharmacy to clinician.
To clinicians. Yes,
Yeah.
yes. So
But on the extreme view, I think, I don't mean that rudely, but the extreme view taken by the claimants, even the supply from the pharmacy to the clinician is a supply. It's a supply until the moment the stuff goes into your eye.
Yes.
That's what I understood the position.
that,
My lord, it isn't with respect, because it's
well-
within the same entity, so there can't be a supply, it's simply moving within the same entity. It was very clear that in relation to mode 2, the relevant supply is by the hospital effectively to the patient for its administration to the patient. That's the relevant
But
supply.
is that not a supply that you say is governed by Article 6?
It is, yes, but it's not. We don't focus upon the supply by the pharmacy to the doctor administering it, because that's within
all right, well,
the
I
same
may have
legal
mischaracterised it. I may have, but in a sense it's a correction that doesn't affect the main point, which is that Article 6 is the need for the marketing authorisation is still there at the moment of the supply to the patient.
It's back to my, can you make it in the garage, and having made it
Well,
in the
that's
garage.
another point, but
It's with respect to-
just stick to the, yes. You, can I be quite clear about this? You say that the supply by the clinician to the patient by the injection generates a need or attracts the need for marketing authorisation.
We say, and I was,
No, is that yes or no?
Yes.
That's fine, that's all I need.
we say that's a retail supply, and modes 3 and 4 are wholesale supply. That's what I said before.
I know.
we could do the same.
Okay, thank you. Well, I misunderstood Mr. Delamare's point as to detail, but I understood it as to substance.
Right,
Yes.
but you say that the supply from hospital A to hospital B to treat hospital B's patient is a retail supply, not a wholesale supply.
Yes.
And Mr. Delamere says it's a wholesale supply.
that's right. And
And if it's a wholesale supply, it doesn't fit within 42 bis, but if it's a retail supply, then it might.
well, I'll come on to the wholesale supply a bit later, my lady. But because we said this is a red herring, but in principle we say hospital A to hospital B is that retail supply. Answer yes. Definitive decision of the Court of Justice in IEFA. See the detail of the Advocate General's reasoning, which expressly looks at that question. I can take the court back to it if it would assist. It's at paragraphs, I think around 50. I'm sorry, it's not 50, it's 82, page 693. Is Hospital A supplying Hospital B retail supply for the purpose of Article 42 bis? Answer from the Advocate General at 81 to 84, yes. Hospital 1 to Hospital 2. What does the court say? Answer, that is expressly adopted. See paragraph 77 at 719. Is there a volume limit which flips it over to being wholesale? No.
So in 82, when they talk about single unit products or small quantities, that's just referring to the individual syringes, is it not?
fact referring back, my lord, to the Corona decision, where which says that's the normal meaning of retail supply, but then one goes on to 83 and asks the question, is a much bigger supply, because Apposite was supplying throughout Germany, according to the facts of the Apposite case, and of course in IEFA this was bulk supply, because this was a system that was operating throughout Italy. So one moves from 82 small scale retail supply through to, well, how does that affect bulk supply but to another hospital? Answer, the logic of Apposite is it's still retail supply.
Is it an accurate paraphrase of 81 to 84 to say that in this context, possibly not in others, the concept of retail isn't about volume? The concept is whether in reality it is a supply to the end user.
Yes.
And they say this is a supply to the end user, even though it actually goes compounder to clinician, or compounder to hospital to clinician. Or none of those steps count really, because as they make the point they make in the last para, only the hospital could supply it anyway.
Precisely. It's a prescription-only medicine, and therefore the only person you can lawfully supply it to as part of a retail supply is the doctor who is going to inject it into the eye, because you can't supply it direct to the patient because it's a prescription-only medicine. And therefore, if it's to have any meaning at all in this context, it means to the doctor who's going to inject the patient. So effectively the doctor is the agent of the patient in that sense, retail supply. The doctor is the person whom you supply for the purpose of carrying out the function for the patient.
It's not so much that it's a prescription only, it's that it can only be administered to the patient by a clinician. You can't
Yes.
inject yourself. So with tablets, you do get them straight from the pharmacy.
My lady's right. My lady is this is a drug which requires the intervention of a skilled professional, a skilled medical professional, in order to complete the medical task for the benefit of the patient. My lady, yes.
And for what it's, I don't know how much can be built on this, but it's a slightly soft reference to the prescription-only requirement in Apposite, because at the end of 83, what he says is, with regard to this, the court assigned particular importance to the question of knowing,
Yes.
as if that's evidential of it being retail supply rather than a condition as such. Now that may not ultimately be a fair way of reading Apposite, but that is the flavour that comes out of that sentence, isn't it?
Yes. But my lord, can I just deal with retail supply, with prescriptions very briefly? Essentially, you appreciate my position on behalf of the CCGs is we just want to know what the answer is. If supply by mode 3 requires a hospital trust to set up an advanced prescription system, then as long as we know, that can be built into the operational policy of the trust. But can I point out to the court that the rules of the scheme in Italy were set out at paragraphs 27 to 29 of the Advocate General's opinion at 684. And they were a prescriptive scheme. And what we're talking about here is not, does this medicine need to have a prescription before it's administered? That's not the issue. The issue is whether or not there has to be a prescription in existence in advance of the compounding. Because this drug can never be provided to a patient without a prescription. So the question is whether it is a rule of the scheme that you have to have the prescription in advance of the compounding in order for the compounding to be lawful. And my lords, my lady, that actually divides that into two separate questions. The first question is whether or not the compounder has to have the prescription in their hand before they can lawfully do the compounding. And the second is whether the compounder has to have the prescription in their hand at the point that they do the supply. In other words, can and I'm afraid we make a number of very straightforward points. The first is that Article 42 bis does not require an advance prescription before a pharmacy can lawfully do a dividing up. So it's not like Article 3.1, which specifically provides for that, and therefore that can't be a coincidence. That must not be part of the scheme. Secondly,
But given that 40 is dealing with manufacturing, and this is an exemption from the requirement to have a manufacturing authorisation, if it's a requirement of that exemption that there is a prescription in existence, then I would have thought you did have to have it before you actually do the thing that you would otherwise need to have an authorisation for.
my lady, the point, yes, my lady, I'd like to dissent from that. The point that is a very important one. Does not say that there must be an individual prescription in place before the dividing up happens. It's no more than that. It's not part of the statutory scheme. Secondly, if the logic of the position from the Commission is right, that a retail supply is lawful where a lawful dividing up has happened, it does appear to be the position, because that of itself is not a fresh placing on the market. The scheme of the directive does not have within it a requirement there is an individual prescription in order to complete the retail sale consequent on the dividing up. And my lord, the reason why that must be right is because the exemption under Article 42 bis will apply to both prescription medicines and non-prescription medicines. And some medicines are prescription, some are not. But the same provision applies to both. And we can't impose a requirement to have an individual prescription in respect of something where, for at least part of the time exercising the rights under the directive, there is no individual prescription because one is not needed for prescription because these are not prescription medicines. So the schema doesn't make sense by the reading in of this additional criteria. And one adds to that the point that the purpose of the directive is to promote public health. And public health, we say, is protected in the existence by the existence of a prescription only medicines. But the timing of the prescription, and this is a timing point, is not protected by public health. In fact, the reverse. Because if what is happening is that the scheme of the directive requires a delay between the clinical judgment of the doctor yes, you need an anti-VEGF drug, and we're going to provide one to you. And then, but only at that point, when I write a prescription, I then send the prescription off to the pharmacy. That's the Avastin model. I think my own friends say, oh no, it's even got to go to the compounder. So it then goes to the compounder. You get this expensive administrative paper chase. You then get the compounded product when there's a sufficient batch back to the hospital. And then it goes for the patient, and the patient is treated, and the injection. All that works against public health, because all of it builds in delay and an administrative process with no benefit whatsoever. And so the reading in of this additional requirement into a directive when it's not there would be against, we submit, the fundamental structure of the directive, which is to promote public health. Because obviously public health would be far better protected by having a stock of aliquots, of syringes, which the moment that you decided a patient had a need for the injection, at that point you say, well, wait there, I'll come back tomorrow, and by that point I'll have written up the authorisation. So public health is protected by the prescription, but not by the delay and the paper chase. And so what we say is that add to that, both in APOSET and in AIFA, they're both recognising that this is specialist medicine, it's prescription-only medicine, the classification of which is a matter for national authorities. And therefore, under the rules of both Germany and Italy, you're required to have a prescription. But we say that the rules in AIFA, in fact, don't require an advance prescription. And therefore, whilst the language of the judgment refers repeatedly to an advance prescription and prepared on the basis of an individual prescription, in fact that has two meanings. Either you have to have it in advance before you do the compounding, or you have to have it in advance before you do the treatment. And therefore the question is, can you read this paper chase into the requirement in circumstances where by definition there will be a prescription, where you don't need the manufacturing authorisation for the pharmacy supplying hospital A to hospital B, and where public health is protected by the fact of a prescription and is aided by having a stock. And therefore, this is an inexact science. I make our position quite clear. If we have to go through this administrative paper chase, it'll build an additional cost. It'll still be well worth it because of the savings, but we'll do it.
Well, you say it's a paper chase, but what about the provisions that Mr. de la Mare showed us about what actually the person who looks at the prescription is supposed to do before fulfilling the prescription? Isn't it supposed to be another layer of checking that this is actually the right thing for the patient?
Well, my lady, that would be a policy reason in a one-off arrangement where an individualised compounding was required for an individual patient. But what Mr. de la Mare referred to was guidance. And the question therefore, and guidance which leads to an audit against certain criteria, which then leads to a report to the chief pharmacist, where if you're then departing from the guidance, you have to come up with a good reason as to why you're departing from the guidance. It's not law, this is very, very soft law. In these circumstances, as the cases make clear, as the evidence makes clear, all of the patients are getting the same prescription. The aliquots, the process, I don't for a moment suggest there aren't challenges to the process. of getting the process sterile and correct. But they're not challenges associated with differences between patient A, patient B and patient C, because they are the bulk production of safe, sterile medicines to be then used all in the same way on patients who have been selected by a medical professional who is treating the patient. So there is no role for checking the clinical appropriateness in this type of circumstance by the compounding pharmacy. The compounding pharmacy has a difficult enough job as it is. I don't for the moment suggest it's straightforward. But its difficulties do not include making different aliquots for different patients. They are entitled to rely on the professionalism and expertise of the ophthalmologist at the treating hospital for all the reasons set out in the IFA judgment, all about bulk supply. And my Lord, if there's any doubt about that, the role of the checking clinical pharmacy, checking the individual patient, of course occurs not at the compounding pharmacy, hospital A, but at the dispensing pharmacy, pharmacy B, because this is a pharmacy to pharmacy transaction, and the clinical pharmacist at Newcastle is the one who has responsibility for, as I tried to explain this morning, for checking that the drug, when it leaves his or her pharmacy, is properly appropriate for the patient to be treated by the Newcastle doctor. What Liverpool are doing is I mean maybe others, but I'm using the example of Liverpool. They are involved in the bulk production of identical aliquots without reference to the individual patient. And they've done that.
Yet it's still a retail supply to that patient.
It's still a retail supply, and the reason is the reason.
Not a wholesale supply.
It's not a wholesale supply, and the reason is if your ladyship would allow me to take a trivial example, Tesco sell a very large number of pork pies. They sell thousands and thousands and thousands of them, but none of that bulk results in wholesale supply, because what they are doing is selling thousands and thousands of identical supplies on a retail basis. The question, and it's a question of law.
Yes, but if they sell a whole lot of them to Marks and Spencer's,
That's
then
wholesale.
sell on, then that is wholesale supply.
Indeed, my lady.
Right, they don't. Yeah, so it's not really a.
But if they sell them to a hotel, which then uses them for its guests, that query, where does that fall in the definition?
It's quite clearly a wholesale supply.
Well, my lady, the answer from the European Court, right or wrong, and we are but servants of the European Court here, the answer from the European Court
Well,
is
the
that
analogy breaks down because you can eat a pork pie by yourself. You don't need the hotel to actually administer it.
I knew this was going to be a disaster. But my lady, your ladyship's perfectly right. But the key question in this slightly difficult exercise is on what side of the dividing line is it? And I'm not relying on an example by analogy, hospital A, hospital B doing something else. I rely on a decision of the Court of Justice, a very recent decision, which expressly decides that even if that doesn't quite fit how one would normally look at things, it is a retail supply.
Right, but there's an inconsistency with its finding that that's a retail supply and its apparent finding that you need to have a prior prescription before you make that supply, which, as you say, makes it a very odd thing. But you say, well, you emphasise the fact that it's a retail supply and therefore the requirement for the prior prescription must mean something else, whereas the other side emphasise the requirement for the prior prescription and say, well, retail supply must be something else. We'll have to decide where
Well,
it's...
you might be able to reconcile the two, mightn't you? Not in a way that helps you on your primary case, but by simply saying there's no real inconsistency. The existence of a prior prescription. Well, if there wasn't a prior prescription, the analogy would be one business supplying to another business for on-sale supply to the ultimate user. So, non-retail.
Yes.
But where it is, as it were, ordered for a particular end user, for which of which the best evidence, and perhaps the only example, is a prescription, then the character of the intermediate hospital is transformed into that simply of a mere conduit. There's a step that doesn't count. I'm mixing my metaphors. So the two, the conceptual basis can be reconciled with the requirement for a
Can. But my lord,
prior prescription.
Lord, perhaps, can I just make two very short submissions in response? The first is, we have the scheme in Italy, and we know that it doesn't have a prior prescription requirement. It has a prescription requirement, but not a prior prescription. The second point is, would the court be kind enough to pick up tabs, bundle C, tab 27, which is AGCM, and I take you to paragraph 55,
So page 669.
yes, paragraph 55, and invite you to read paragraph 55. And therefore, using the benefit we can from multiple cases, it is as clear as mud as to whether the system in Italy in fact had a prior prescription requirement, whatever the Court of Justice might have said. And therefore the rules which I took you to, which don't have it, appear to be supported by what happened in practice. Well, I can't take the point any further. Can I emphasise, though, that the position of the CCGs is that our primary position is that we don't need to satisfy our primary position is that we don't need individual prescription as part of any lawful scheme the trust set up. But if they are, we'd like to know what the answer is. But we don't need it for the reasons I explained this morning in the policy. Can I now turn to very briefly to the domestic cases around the policy, and very quickly take your lordship through that, your ladyship through that. I'm still on ground one, but the rest of it is very quick. This oughtn't to be controversial. The meaning of a policy, we say, is reasonably understandable from the terms of the policy itself, and that you don't dive into the mind of the policy maker in order to try and provide and put limits or artificial limits on the policy or how it can be implemented. And the authority for that is Raisi in the Court of Appeal, which you were taken to before, but I won't take you to it. It's paragraphs 118 to 123, and the reference is Authorities Bundle D at tab 24. As far as the policy is concerned, at the point that we envisaged the policy, which obviously is stage one of the decision-making process, we didn't know precisely how the trusts would, if at all, implement. So attempting to place limits at that point would have been an wholly artificial exercise. But there is an important distinction in the approach to lawfulness of policies between mandatory decision-making systems and non-mandatory systems. And this is a non-mandatory policy, for the reasons I made this morning, accepted by the judge, no appeal against that. And the maker of the policy is different to the decision maker who has to take account of the policy in making decisions how to act in exercise of their professional judgment. And therefore, the proper test, we say, is Gillick, because all other cases, detention action, refugee legal centre, and letts, all apply to circumstances where the person affected by the policy was required, as a matter of statute or a matter of public law, to act in accordance with the policy, had no choice, and to make decisions that then were binding on behalf of the person who issued the policy. So it couldn't be further away. Whereas Gillick, we say, is different and is much closer, because in Gillick the policy was issued by the Department of Health, but the decision makers were the doctors who were making decisions about what medical services to provide to underage girls who came before them seeking contraceptive advice. And therefore the policy was guiding the discharge of professional responsibilities by somebody else, so it is much clearer. And in Gillick, can I just give you three references? Lord Scarman at 181, B to C, Lord Bridge 193, F to 194, D, and Lord Templeman at 206, D to E, because although he dissented on whether the policy was unlawful, he agreed in terms of the approach to judging its unlawfulness. And all of those...
What was the first reference? The first reference to Lord Bridge, wasn't it? What was the
Lord Bridge 193...
Oh, sorry, what was the Scarman reference?
Lord Scarman 181, B to C.
Thank you.
And all of them support the proposition that a mere possibility that the second actor in this process will act unlawfully is not enough. They all suggest a very high degree of confidence that by following the policy there will be an unlawful act. And the West Berkshire case in our submission is of some use. That's at tab D, at bundle D, tab 41. And this was a case about a ministerial letter, written ministerial statement, which on its face, if followed to its letter, may well have resulted in planning authorities acting unlawfully. And the question was whether those who were obliged to follow it had to follow it on its letter, or whether the author of the policy was entitled to assume they take their own advice, and if they needed to build in exceptions, they would. And the answer from the court was the latter, page 1073. Which I invite you to read to paragraph 21, if you'd be so kind. translating that into the present case, there is no need for a statement to be added to the policy that the CCG is illustrated to say, by the way, you can implement this policy by a number of different routes. Please take your own legal advice so as to ensure that whatever route you choose, you're acting lawfully. And therefore, my lord, the let's line of cases, we say, are not relevant because there is no second actor in that proposal. There is only a first actor taking decisions on behalf of the primary person. And therefore the degree of confidence one would need that there will be unlawful actions in this stage becomes even higher. And the mere risk that in amongst the myriad of possible ways that you implement it, you act unlawfully, comes nowhere near to making the policy unlawful, for the reasons we've set out in our skeleton argument, and I won't repeat. Essentially, it's a very high threshold, and this case, the case comes nowhere near it quite properly in our submission. Well, Lord, I've taken that part very quickly, unless I can assist further on that. My Lord, can I next deal with the appellant's ground 3A, because I've essentially dealt with grounds 1 and 2, and if the court would be kind enough to pick up bundle 1, tab, core bundle A, tab C at page 28, I think it's 1C.
What page did you say?
Page 28, 29, my lord.
Well, I must have muddled myself. Behind, oh, I know, I have muddled myself. Thank you. Yep.
I've got a paper chase today. I'm sorry, I'm taking the court through a paper chase. And I will respond very quickly to the view that the ground, that effectively the judge was wrong because she failed to follow through the implications of the MHRA's finding that CB is an unlicensed medicine. You had my points earlier. There is no such thing as an unlicensed medicine under the directive, which the MHRA now agree with. It is an unlicensed function by an actor in the medicine supply chain. That's what the directive focuses on. And that's that as we understand it. My own friend Mr. Peretz will make it clear. Essentially, the MHRA have changed their view, and we have no difficulty with the new position because it's consistent with what we say the proper interpretation. And therefore, criticising the judge for failing to take through the logic of a position that's now been abandoned gets the appellants nowhere. The argument at 6b that the CJEU has not decided the question as to whether CB for ophthalmic use is unlicensed or off-label, we submit, misunderstands the concepts of the directive, but in any event is wrong. And just for your lordships and your ladyships note, it's plainly an off-label use. See AGCM at paragraph accusumab for ocular use as being off-label. And
Yes, but it's a term which is loosely used, isn't it? I haven't found it, my thinking about it, a very useful tool of analysis. It's not a term which appears anywhere in the directive.
Indeed, and the reason it doesn't appear in the directive, my lord, is because the directive does not classify drugs by virtue of being licensed or unlicensed. It it controls the actions of actors in the market, in the supply chain, and defines the circumstances where companies need either marketing authorization or a manufacturing authorization.
It's the fact that it may be off-label for the purposes of looking at how the clinician is using it doesn't tell you anything about the legality of the supply that got it to the clinician.
Indeed, I think that's absolutely right. The question is a much narrower one. It's, has the supply been made in circumstances where it constitutes a placing on the market, in which case you need a marketing authorization unless you're exempt, or is it or is there a manufacturing process, in which case you need a manufacturing authorization unless you're exempt? The argument that NICE and the GMC regarding the use of CB are not relevant, as they must defer to the MHRA's view, which we say is wrong for the reasons the judge found about the non-exclusive competence, and the argument that the evidence didn't show there was anything beyond use of CB as specials in the market is equally wrong. There is no appeal against the findings of the judge on that point, and therefore the judge's findings, as a matter of fact, are what they are, and she plainly found that there was a mature market. The mature market is important for this reason, my lords. We started in circumstances where the clear evidence was that in the private sector in the UK, you can choose your treatment of choice from a menu which includes Lucentis and Eylea and Avastin. And Avastin is much cheaper. And there are published menus of prices from private hospitals. That's the way it works. And that's the evidence of that was before the court below. And no question of special needs or anything like that. It's simply an economic choice made by patients and doctors about how to treat patients. And patients in the private sector are routinely treated with compounded bevacizumab. Why? Because it's cheap. It's cheaper, and obviously the doctors think it's perfectly good. And therefore there is a market circulating where the NHS has been constrained to use exclusively the licensed products, as it said, the products for which there is a marketing authorization. And outside that, when people are paying themselves, they use compounded Avastin, compounded bevacizumab. And this whole process started by asking the question, well, why should the NHS have to be subject to a framework for drug choices that simply doesn't operate in the private market, when people can choose for themselves and ophthalmologists are making choices, when the directive applies equally to both the private market and the public market for the supply of drugs.
What's the legal significance of that? I mean, they could both be unlawful or both lawful.
They could both be lawful and unlawful.
But the existence of custom in the trade, does that really,
Well, my lord,
really help us on the questions we have to decide?
the problem, Lord, is this, and this is the way the case was put below. The actors in that market who explain how they supply compounded bevacizumab lawfully were not before the court. So we know this market was occurring.
Well, you tried to run a case that they couldn't now challenge the lawfulness of the use because they'd let this market develop, but the judge didn't accept that.
No, indeed, and I don't appeal against that decision, and that's fine. But the judge was essentially in no position to judge, we respectfully submit, how the market operated, because there was simply no evidence from anyone.
Why did she need to?
Because, my lord, we say, because, my lord, essentially the case made against us was, it is impossible for anyone to supply compounded bevacizumab by way of a commercial supply. It's all unlawful.
Well, hang on, impossible legally.
Impossible legally.
Well, but all that means is that if there is indeed a mature market, the actors in that market may be acting illegally.
Yes.
Well, we have to decide whether they are or not.
Well, my lord, yes. I don't think it goes.
I've never quite understood where this point went, and I'm afraid I.
Well, my lord, the
The fact that they may be able to think up some better argument if they were here that's escaped you, I'm afraid is a hazard of litigation. All sorts of people are stuck with decisions that they think, oh, it would have all gone so much better if I'd been arguing it. But
well, my lord, there are many people who standing here would argue this far better than I would, but that's an equal.
that's the breaks.
That's the way that the cookie crumbles, I'm afraid. So be it. I move on. Ground 3B, and the proposition under ground 3B is essentially that mode 2 is a placing on the market. In other words, and as I understand the case that's now put against us is not quite what we understood below. A hospital compounds in its own pharmacy. It then passes the product to a doctor in an outpatient clinic, and the process of injecting the patient constitutes a placing of that drug on the market. That's the argument we have to meet. The fact that the domestic regulations have referred to a sale or supply is an illegitimate method of interpreting the meaning of the directive. The directive cannot be interpreted in my submission it's like trying to interpret the meaning of primary legislation by looking at secondary legislation. You can't do it that way round. You can do it the other way round, but not that way round. And we simply say that the natural meaning of the language placed on the market requires a buyer and a seller. And it requires a market where the seller is marketing it and the buyer has a choice of products to buy. And that's not the natural language of a doctor injecting a patient. And we respectfully agree with the Secretary of State.
But what about in your private sector then, where the patient does pay for the drug? Is that then a placing on the market?
Now, lady, I would say in those circumstances that, subject to the apposite exemption, the market exists between the pharmaceutical companies that supply the private hospital and the private hospital itself. But once the drugs are in the private hospital, the administration of those drugs pursuant to a service which the patient's paying for is not the placing on the market of those drugs, because the patient is not buying the drugs. The patient is buying a medical service, a small part of which is the drug.
There's quite a lot of case law on this very point in relation to consumer protection legislation. But that, of course, is about the language, I think, of supply and sale rather than placing it on the market.
Yes. But we would say,
But I think aren't you getting a bit dazzled by the fact that it has to be administered by the clinician? I mean, many times when you go into hospital, you come out, before you're discharged, you're given a little bag of pharmaceutical products to take home and take one a day for the next however. Right, and if you're in the NHS, you get them for free, or you pay the prescription charge, and if you're in a private setting, you pay for those. Isn't that? How can that not be the retail?
because, my lady, that's all the internal organisation of the health service. 1687. That's how you organise the health service, and whether you choose to charge for that patient by way of taxes, or you charge at the point of sale, that's all outside the competence of the EU, specifically because it's the way you organise your health service. And we say that whatever else 1687 means, it certainly means that that process of supplying drugs to NHS patients within a state-funded healthcare service is not a placing of those drugs on the market. Because the only...
Well, but I mean, that does mean that there would be a distinction between, well, perhaps not. Would that apply equally to the private administration?
A private hospital wouldn't be entitled to take advantage of 1687. That's clear, because that only applies to state healthcare services. Whether it would be a placing on the market for the sale to the private hospital, probably yes. May well be subject to Avastin exemption. But we would respectfully submit that the words placing on the market don't apply to the administration of drugs as part of the part of the private thing. Can I take a slightly different example? Your ladyship's given one example, which is the drugs you're given to go. But of course, most drugs in the NHS in hospitals are used on inpatients, and so a drug which a patient comes into the hospital for oncology treatment is in the hospital, and whilst in the hospital receives treatment as an inpatient or is in the ITU ward, is every time a drug used for a patient in an ITU ward, entirely inside an NHS hospital, placed on the market by the delivery of that drug to the patient? We respectively say no, plainly not. Why not? Because it's the delivery of a public service, it's not the operation of a commercial market. And the...
Well, hang on, is your distinction between a service which incidentally includes a product and the supply of a product, or is that the distinction, or is it the distinction between public and
both.
Private?
It's both, my lord. But
well, they're different points.
They're different points. The public-private, 1687 and not 1687. The other provision is this within the proper scope of the directive? What is the directive about? It's about, as rightly said Avastin, the putting of drugs on the market in the European Union.
So you say that 1687 can have the effect that something is not a placing on the market if it's done for a public health service, but is a placing on the market if it's done privately?
It could be, my lady, yes, because the exemption for 1687 is clearly that what happens within the management and operations of internally to state healthcare systems are matters exclusively of national law.
A lot of state healthcare systems, taking the broad sense of that, are in fact systems under which private hospitals provide services to everyone and then reimbursed by the state or paid under a state insurance scheme.
Indeed, my lord, and there are clearly some difficult questions at the edges, and I'm not trying to give a sort of explanation that covers every case, because I don't need to, because in the circumstances we're concerned with, this is wholly operating within public bodies. And where it's wholly operating within public bodies, we respectfully say that the question as to how the boundaries operate simply doesn't arise, and therefore, luckily, those difficult questions don't have to be addressed in what already will be, I fear, a fairly substantial judgment. But essentially, my lady, we say, supported by the Secretary of State, that this is management of the health service. This is how the health service is managed, it's operated, and therefore internally, the internal processes within a hospital trust do not constitute a placing on the market of the drugs that eventually end up with patients, because there has classically been, because in fact they have already been placed on the market, to adopt the language of Avastin. They have been placed. That was how they got to the trust. It's not a fresh placing on the market. It offends the meaning of the language to do so. There is no market.
Well, it offends the meaning of the language that's used in the domestic implementation less, doesn't it? Sale or supply is not quite so offended.
Well, my lady, I'll deal with that under the wholesale distribution point that I'm going to come to in a moment. Can I adjourn my submissions until then? Because they all, in many ways, these submissions keep coming back to the same issues. And look, my Lord Justice Underhill is perfectly right. To some extent, this case turns on the meaning of placing on the market. Can I?
At some point, not necessarily now, just help me a bit on recitals 35 and 36, which don't do it now, but I'm still not quite clear how those tie in with your construction of the directive.
My Lord,
talking about controlling the chain right through to supply.
that's right. My Lord, a very simple answer to this. Few things are simple in this case. I think this is a simple answer. The scheme of the directive essentially provides for the control of actors in the market, the chain of manufacturing and then sale of medicinal products, to the point that public health is protected by a medical professional. And the reason that there are pharmacy exemptions is because the scheme protects the supply chain until they reach a regulated professional. And therefore, public health doesn't need to be protected. The scheme of the directive doesn't need to protect of itself what a pharmacist does, because that's protected by the domestic regulation of those clinical professionals. And we say that Regulation 35 is one of those areas where it arose, where there may indeed, as Judge Sharpston said, be some difficulty in tying up all the bits of the directive, because of course what she said was the reason that she came to the opposite view in Avastin was precisely to give effect to recital 35, recognising the tension between, on the one hand, the only thing that's prohibited is placing on the market, on the other hand, the desire for end-to-end protection.
But another way, possibly, it's not quite the same point. The concept of a chain of distribution, like most metaphors, is rather inexact.
Yes.
And the question is, what's the last link in the chain? You could say, perfectly, perhaps the most natural reading would be the last link in the chain is the retail supply to the customer. But depending on context, you could say the chain of distribution stops at the retailer. And from then on, you don't really call that distribution, that ceases to be distribution. That then becomes the ultimate supply.
Well, that picks up precisely, my lord. Can I take the court back to Avastin, because at bundle, it's the back of bundle B, because it's the question posed by Judge Sharpston. It's tab 22, paragraph 58. Authorities bundle B, tab 22, paragraph 58. the more, bearing in mind that Judge Sharpston was adopting a more inclusive interpretation of this than the court, her definition was that the requirement under Recital 35 is only spent when the marketing process
Yes.
can be said to have terminated, and that would fit with Lord Justice Underhill's point that the final.
So she says in the next sentence, right at the end, by being disposed of, it has been disposed of by being supplied to the public.
Yes,
She doesn't take my view, I don't think.
but
But she may not be right.
picking up, if I can, the what's meant by supply to the public, and using the way in which the phrase was interpreted as public supply in AFA by the Advocate General, then adopted by the court, which is a supply to the hospital, Hospital A to Hospital B, is treated as a supply to the public. You then, if you put those two together, you end up in the place posited by Lord Justice Underhill, which is that the final person who in effect manages the process on behalf of the patient is the final person to whom the drugs are marketed, but is not of themselves, is a placing on the market. My Lords, can I press on to the note? I'm conscious of time. I'm sorry, there's one point that 3D, which is undermining the scheme of the directive. We've set this out in our skeleton argument. I think I've taken you to the key passages. Does the court need to hear from me on 3D?
Well, I think it's a matter of, for you, everything is helpful, but if you've really got limited time, it may be that we will obviously reread your skeleton. But if
Let me take 2 minutes then,
Yeah.
my Lord. There are two answers to this ground. The first is that the CJEU has already ruled in a series of cases that subdivision or dividing Avastin for the purpose of off-label use doesn't offend the essential scheme of the directive, and that's APOSET, that's AGCM, and that's IFA. The second is the one case which is relied upon by the appellants to support this, which is CTRS, is a completely different case. That's at tab bundle B, tab 24. And the background to this case is a completely different scheme for medical regulation. It's the orphan drugs, the orphan medicinal products scheme, where essentially in order to provide the incentive to, my Lord, it's bundle B, tab 24, in order to provide the incentive to invest in producing drugs with, by definition, very small markets, because orphan drugs only treat people with rare conditions, a drug which is within this scheme is given a form of market exclusivity for a period of 10 years, and we see that at paragraph 4 on page 576. And, my Lord, therefore the scheme, by definition, does not allow other competitors in the market covered by that marketing authorisation. And it's impossible to read up from that case, which is involved in a very particular scheme, some form of exclusivity to medicinal drugs, which are authorised, where you get a marketing authorisation under a completely different scheme, to protect you against the competition, effective competition, from clinicians who choose to prescribe off-label. It doesn't work, and it's specifically held not to work. If I can take the court to 584 and invite you to read 78 to 80, and in particular 79. It therefore becomes unarguable. That's all I propose to say about that provision.
May I at this point confess that I left your note in my room at lunchtime, having diligently taken it back for that purpose. Read. Is there a spare copy?
There certainly is, my lord. Right, I have two further issues to deal with. One is wholesale dealing, the other is modification. And it may be, my lords, fastest in view of the time if I simply invite the court to read the note, and then I'll answer any questions that right out of it. Or I can try and take you through and explain the reasoning. It's entirely whichever's most
Well,
convenient.
on the Stratford's timetable, you've got another 40 minutes. I know you had threatened Mr. Perrott to be on his feet, but he doesn't have to be.
No. In that case,
Speaking for myself, I think it would, the idea of challenging us to cross-examine you, we may find that comes naturally as you go through, but I think I'd rather have submissions in the usual way.
okay, fine. Well, my lord, in that case, as I understand that
But you can obviously take it faster because it's all written down.
yes, as I understand the argument, it's got three strands. First of all, the 2001 directive or the Human Medicines Regulations requires a pharmacy that wishes to compound bevacizumab to have a wholesale dealer's licence. The directive and the HMR require the holder of a wholesale dealer's licence only supplies medicinal products which have a marketing authorisation. And CV does not have a marketing authorisation because it's not distributed in accordance with the product's summary of product characteristics, and thus any supply will be unlawful and a criminal offence. That's the argument, as I understand it, against me. And this is an entirely new point, but we'll do our best to argue. It would have been nice to have a few weeks to think about it, but we'll do. We've burnt the midnight oil, and this is the best we can come up with. It's necessary to start with a proper understanding of the exemption for manufacturing authorisation, and that takes us the next. I've taken through paragraphs 3 to 5, takes you through the solely for retail supply exemption in
which
42
we've seen
bids,
already,
and I've made those submissions. I don't need to make them again. There. So the effect on paragraph 6, classifying this supply as a retail supply, has other consequences under the directive, because there is a division under the directive between wholesale distribution of medicinal products and retail sale. Wholesale distribution is defined at Article 1.17 as follows, and I think you were taken to that. And of course it doesn't therefore include supplying medicinal products to the public. And there's no limit in the definition on the number of medicinal products which can be supplied to the public. And we say this is consistent with the usual meaning of wholesale dealing, namely a transaction from one seller to another who intends to sell on the relevant goods, because wholesale dealing does not normally include sale to the final customer. The reasoning of the Advocate General in IFA, which again I've taken to twice, I think, and I'm not going to take you again, explains why proper interpretation of the directive, a supplier of medicinal products to a hospital which will use them to treat members of the public should be treated as not being a wholesale supply and thus making a supply to the public. It's on that side of the fence. Such supply is a supply of medicinal products to them.
You said that whole question was not a matter of EU law. It's a matter of the management of the health service and therefore not covered by the directive under Article 1687. So can you really have it both ways, of saying that the Advocate General says it's a retail supply, not a wholesale supply?
Yeah. Am I really trying to have it both ways? I hope not. No, Melody, can I explain? We say as our primary line, this all happens within the health service, and if it happens within the health service, it's excluded from the directive 1687. If we are wrong on that, and 1687 doesn't extend as far as that, then one has to look and ask the question, is this a retail sale or is it a wholesale sale? Where does it fit into the scheme of the directive? And it's retail supply. So if we are within the directive, because we're not excluded because it's the NHS, then it's still retail supply, see Advocate General in IFA and the court in IFA. So I suppose I am slightly trying to have my cake and eat it, but it's actually a primary and a secondary submission rather than trying to do both at the same time. So my primary submission is obviously that, but I'm now dealing with this in an alternative way to try and meet the point. So the reasoning of the Attorney General, the Advocate General in IFA, explains why proper interpretation of the directive, a supplier of medicinal products, I should say by a hospital pharmacy to a hospital, which we treat them, should not be regarded as wholesale supply and thus making it supply to the public. Such a supply is to supply medicinal products to the public because there's no further stage in the chain of distribution. According for the purpose of the directive, hospital pharmacy that compounds CB is not engaged in the wholesale distribution of pharmaceutical products. I will...
Is there a not this in there? Such a supply is not a supplier because there's no further stage. Oh no, sorry. Yeah, I see. This is a supply hospital to hospital. Supply from pharmacy to hospital.
It was extremely late when I wrote this, so
No, I'm confusing you then.
the substance of it is, I hope, clear, even if the language has got slightly garbled.
Yeah.
Can I invite the court to pick up the directive? Because there's one aspect which it is of some importance. Looking at Title 7, which is page 82, tab 3, bundle, authorities bundle A. And what I draw the court's attention to are the words in bold and capitals just below Title 7.
What page, though?
Page 82, my lady. So, brokering is also very clearly defined in Article 117A, and I've set that out of paragraph 9 of the note. And a hospital pharmacy that compounds CB is not brokering. So we submit that the provisions of Title 7 ought to be interpreted only to cover those engaged in the activities caught by the title, namely wholesale distribution or brokering. Hence, for example, distribution in 76.1 that Malone Frems Delamere relies on so greatly must mean either wholesale distribution or distribution as a consequence of brokering, because that's the scheme of the part of the directive we're in. And accordingly, the activities of a hospital pharmacy, which is not engaged in either wholesale distribution or brokering, for the reasons that I've explained, is outside the scope of Title 7. I then deal with the question of marketing authorisation, which I've covered in submissions, so I don't need to go further than that, because that I hope summarises the submissions I've already made. And we then get to paragraph 20, which is the consequences of the scope of the directive for the proper interpretation of the human medicines regulations. Because the vires in relation to the imposition of regulatory requirements to have a marketing authorisation under the regulations arises solely in respect of powers of ministers under the European Communities Act 1972 to make regulations to implement the 2001 directive. There are other provisions enabling powers under the Medicines Act 1968, but we've looked at each of those in detail and they do not apply, they are not relevant for these purposes.
Yes, I don't think, I haven't actually checked, but just looking at the index, we don't, I think, have the, do we have the front page of the regulations? Perhaps we do.
I think your Lordship does.
So that will be, which bundle is that fall in?
B, my Lord.
Tab 13, page 386.
Tab 13, and it's page 386, which has got.
Oh, we have got it, yes.
You have. Yes.
So I see. So the vires are, as you say, they start with the 1972 Act,
and then there
and
is.
then various other. Yes, you've looked at each of those and say that they're not material.
Yes.
I looked at them too overnight, and I can rather than print them out. Section 87 is about requirements of the containers. Section 88 is a provision dealing with distinctive colours, shapes and markings. And sections 91 and 129 are both regulation making powers.
Yes,
So they don't deal with anything
Well, if
substantive.
Mr. Dillemeyer seeks to persuade us otherwise, we can hear. But
Yeah.
that all looks likely to me. Yeah.
My Lord. So the relevant position, in any event, we say explain the relevant provisions, pick up and implement the provisions contained within the directive relating to the need for marketing authorisation. It follows, we respectfully submit, that the regulations could properly define criminal offences by relation to the contravention of an activity which was within the scope of the directive, because that's the way the creation of criminal offences is how is one of the means which has been chosen to police the operation and ensure that the UK state is rightly implementing the directive. But the provisions of the human medicines regulations, we submit, should not be interpreted as penalising the undertaking of any activity or the carrying out of any function which is outside the scope of the directive.
Sorry to be pernicious about this, but I just haven't quite understood it. I understand why both sides have focused on the existence of criminal offences, but they're not actually the essence of the matter, right? If the regulation said such and such shall be unlawful, but didn't say they were an offence, we'd be in just the same place,
Yes,
as far as the law.
But the reason that I referred to the criminal offences is because, first of all, they have to be interpreted restrictively, and secondly, they are the source of the submission made against me.
Yes.
But your Lordship is perfectly right. Whether it's chosen to implement by regulatory requirement or by criminal offences, in a sense, is by the by. The important point, we respectfully submit, is the provisions of the HMR go no wider in proper construction than the scope of the directive.
And even if they appear to, they will be ultra vires if they in fact, they must be interpreted in such a way as to bring them within the vires.
Indeed.
Yes.
Precisely. So the matters raised by the appellants are not an issue about, we say, about the way the regulations apply to the NHS. On their case, a private hospital following AFA that compounded Avastin in order to make the compounded product to another private hospital would not need marketing authorisation of the directive to undertake that supply. Because the fact it's a regulatory scheme is not a scheme. There are exemptions for the NHS, and one of my cases the exemptions apply. But in fact this part is not about the NHS, it's about the scope of the scheme. So if EU law requires internal transactions within a member state healthcare system to be treated as being outside the scope of the directive or permitted by the directive, in other words, not impermissible, the HMRs should not be interpreted as extending the scope of the regulations to regulate matters which are outside that scope. There are, of course, rightly, areas where the directive leaves matters for the law of member states. I think this is the interstitial part referred to by Mr. de la Mare. And the granting of authorisations to persons other than someone who operates a pharmacy to undertake the division of drugs, the dividing of drugs, is one such area under Article 42 bis. However, Article 4.3 provides that the provisions of the directive cannot affect the powers of member states to decide what drugs should be included within the member health care services, including the NHS. And that doesn't prevent a member state passing its own laws concerning such matters, but it doesn't give vires for laws to arrive by virtue of the directive. So essentially, my lord, our position is summarised in paragraph 24, which is no provision in the regulations should be interpreted to criminalise conduct which falls outside the directive. So if our primary case is right about pharmacies having the right to divide drugs and then conduct retail supply, is right, and that's outside, that's permitted by the directive, you can't, there's no vires for the human medicines regulations to be interpreted in a way which criminalises that conduct. And if therefore the complaint is essentially you ought to have had a wholesale dealer's licence because under the terms of the human medicines regulations you're required to, by the way that on the face of the words they interpret, even though under the directive it's outside, the answer is that you can't interpret the human medicines regulations in that way.
Because you say you could have done that by primary legislation if you wanted, but you can't do it through regulations made under Section 2.
Exactly. And therefore, the whole scheme that we're concerned about is the implementation of the directive. So it's a sort of bootstraps argument.
So, modification.
Modification. My lord, I can deal with this, I hope, reasonably swiftly. As I understand it, the case advanced by Novartis has 5 stages. When Avastin is compounded, the drug that is produced by the compounding process has different characteristics to the drug prior to the compounding process, such as a different shelf life, risk of contamination, and a whole series of other risks. Those different characteristics mean there is a modification of the drug when it is compounded, because the drug coming out of the process will have a different shelf life to the drug going into the process. The court in Avastin was exclusively focused on packaging.
Sorry, if you are saying 5 points.
Oh, sorry, that was point 2.
Yeah.
Point 3, the court in Avastin was exclusively focusing on packaging. and accordingly didn't appreciate that the different characteristics of the drug meant it was inevitably modified. Point 4, hence, within the meaning of paragraph 42 of the judgment in apposite, the drug, of course, had been modified on this, albeit nobody appreciated at the time. And point 5, therefore, any national court asking itself the question whether any compounded process involving Avastin involves a modification is required to come to the conclusion the drug has been modified, and thus the conditions in paragraph 42 of apposite cannot, by definition, ever be satisfied. That's the argument against us. It's a clever, extremely clever, but misconceived argument. And because it fails to appreciate the link between paragraphs 36 and 42 of apposite, between the dividing up provision and Article 42 bis and the conclusion on modification. And the CJEU has or held that the dividing up of Avastin is lawful, is not prohibited by the Medicines Directive, and we see that AGCM at paragraphs 58 and 59, Authorities Bundle C, tab 27, which I've taken you to, and I'm going to take you to again. But I would, the final nail in the coffin of this argument, ingenious as it is the opinion of the Attorney General, Advocate General, at paragraph 56 in IFA, Authorities Bundle C, tab 28, paragraph, can we start with paragraph 45? Because 45 is a reference, which I should have taken you to earlier, to the importance of Article 1687 of TFEU. But of course I accept that that is subject to the rules, whatever the rules of the directive are. But if we can go on to 55 to 57, and you will see there.
Would you like us just quickly to read this paragraph?
It might be if I can ask you to read 55 to 57. So the type of modifications which result in a different shelf life, are plainly within the knowledge and purview of the court. And what modification means is the addition or subtraction of the essential medicine in the syringe, and we see that from paragraph 57, and the conclusions over the page at 61 and 62, about 8 lines down, 61, providing the medicinal substance itself is not altered. Does your lordship see that?
Yeah.
So we're in the business of dividing up.
Does that mean that Novartis retains pharmacovigilance obligations for use of, Roche retains pharmacovigilance obligations in respect of a use of Avastin, which is not covered by their marketing
It does.
authorisation?
Yes. It requires, so if it comes to their attention that there are problems with the use of it for ocular, they are obliged to report that to the European Medicines Agency. Yes, entirely accept that. That
Are
is
they liable to someone who
no,
wants to sue them for the use of
definitively not, my lady, because you're using it outside the terms of the marketing authorisation, and therefore any product liability issues would not attract, because product liability in that sense is very strictly limited, as I understand it, to the terms of the marketing authorisation, so you do so at risk.
I didn't know there was. I didn't know there was an express limitation. It would make obvious sense. Not aware of anything in the Product Liability Directive that says that.
Well, that's my general understanding. My learned friend, Mr. Perrott, might be able to help you slightly better, because he's...
I can't, but other than that, as a sort of matter of basic, perhaps tort law principle, I'm not an expert in the Product Liability Directive, but plainly as a matter of basic tort law principle, the manufacturer's responsibilities may well differ in a case where the product's being used exactly as they specify.
Well, that's obviously so. That well, perhaps we needn't go there. In a situation in which a manufacturer knows that although they put something in their SMP limiting the use, that in practice it is being very widely used for something else, for which it knows it is unsafe. Perhaps there's a tricky question, but we don't need to go there.
I mean, what I can say is that my learned friend's right about the pharmacovigilance position.
My Lord, they might be protected by that part of the summary of product characteristic which says don't use it for ocular use.
Sorry, don't.
Use it for ocular
Well, that's what
use.
I had in mind. That's
Yes.
exactly what I had in mind. But if you knew that although you said that everyone was doing it and that you were making money out of them doing it, one could see but it's not a case for us.
It's not a case for us, and of course, people would say, well, I'm entitled to it because the WHO has said, exhaustively looked at this and nicely
The
looked
more
at
we
this.
open this up, the more I think we should close it down.
My Lord, I haven't dealt with, I'm conscious, the GMC position, because the GMC position is comprehensively set out in the judge's judgment. It's set out in our response, in our skeleton argument. As far as the GMC position is concerned, just finishing with that position, my Lord, that the GMC themselves have made it extremely clear by putting out a particular statement that a doctor who acts in the way the Royal College of Ophthalmologists suggests people should act will not, without more, breach the terms of the good medical practice. And in those circumstances, the argument was rightly rejected below for the reasons the judge gave. And I don't propose to take time going beyond what we say in our skeleton argument and what the judge has said, but nothing that has been said in oral submission changes the essential position set out in our skeleton, that the GMC very clearly say doctors are fully entitled to take cost into account. It's part of their professional duty to do so for all the reasons set out by the judge. And in any event, and your Lordship will know this from practice, the finding that you are in acting not in accordance with good medical practice is only the first stage of the process for professional regulatory sanction, because it raises then a case as to whether or not a doctor would be fit for practice. It does not automatically lead to a finding against the doctor, and doctors frequently act and are exonerated for acting against good medical practice in circumstances where they've got a good reason to do so, and then that doesn't lead to a finding of impaired fitness to practice. So stage one is, have you breached the terms of the GMC code? GMC, no, you're not breaching the code. Stage two, even if you are, does that give rise to a question as to your fitness for practice impaired? The simple answer to the point is that the GMC, having said in very clear terms, we will not regard someone who prescribes Avastin as being in breach of our code of practice, would face a solid judicial review complaint if they ever tried to bring a doctor before the medical practitioners tribunal for doing precisely what they've said they will not do. They've made a very, very clear statement. So the argument that in some way that makes our policy unlawful is nonsense. And that's the weakest of many weak points that's made against us. This case is not about that. It's not going to turn on that for the reasons the judge gave. My Lord, it's 4:20. Although I apologise, I haven't been on my feet all day. Is there anything else I can assist any member of the court with?
No, thank you very much indeed, Mr. Locke. Well, Mr. Peretz, rather as I said to Mr. Locke, if we are short of time, we can, and you can usefully use. I can't sit beyond 4:28 because I have a meeting at 4:30. We'll use it, but we won't insist on you starting now if you think we're going to be comfortable tomorrow within the estimates given.
I subject to the obvious caveat that is in your lordship's hands as to the time I spend. If it assists in terms of pre-reading, I'm not going to really be referring to any material other than the apposite and AIFA cases with which your lordship's own lordship will already be entirely familiar, but I will need to go back to them to make some further points. Obviously the text of the directive itself and the relevant provisions, again, with which your lordships will be familiar, and relevant bits of the Human Medicines Regulations and Section 10 of the Medicines Act. So in terms of pre-reading, I suspect your lordships are already pretty familiar with everything I'm going to
Speaking for myself, I will reread your Stoican argument to the light of the
Indeed, and that would be. I hope not to cover the same ground. What I'm going to spend my time doing is really responding to the points that have been made, and as your lordships will appreciate, to some extent we're steering a mid-course between the parties, between Scylla and Charybdis, to use the metaphor, hopefully without losing too many men overboard as we do so. I could very briefly start now, but I'm pretty confident I will be within 2 hours, and
I think it's
including me.
clearer that we will stop now. So far as tomorrow is concerned, we really can't sit at all late. So everyone will have to cut their coats according to their cloths. It may well be that actually we finish very comfortably within the time, but we can't go on.
My lord, just to speed the plough, if you have a chance, bundle B, tab 33. There's a note. Supplementary bundle B, tab 33.
Yes.
There is a note that Miss Stratford and I produced, and our teams produced below,
Yes.
that explains the interaction between NICE and the MHRA. I think it's going to...
It may well do, but it actually says be nice and
GMC.
But
Yes, that's the second topic in the notes, but it's tab 33, my lady, page 537. What I wanted to indicate was I asked my learned friend Mr. Peretz whether there was anything in the note up to paragraph 19 where it starts to get case specific that he agreed or disagreed with, and he's confirmed, I think very helpfully, that what we said at paragraphs 1 to 18 is a correct description of the relevant regulatory roles of NICE and the MHR.
Are you inviting us, for our own education, to read those paragraphs overnight before
Yes,
we...
please, because it will speed up what we have to say in response
Very
to
well.
what my learned friend
I'm
Mr.
sure
Locke
we
said
can-
about that.
Yes.
Relatively small bit of work.
I can confirm that it's a useful expansion, in fact, of what we say at the front of our skeleton about the roles of the public bodies. I confess that I hadn't actually seen that note when I wrote my skeleton, but it's a useful expansion of it, of what we say.
Very well. 10:30 tomorrow.
Please.